are live.
All right, welcome to the House Judiciary Committee this Wednesday morning, April 8th, and we're going to start with testimony on S-193, an act relating to establishing a forensic facility. And we have two witnesses this morning in the first time slot. And thank you for being here, Kelly Carroll and Leanne Billings. I guess we'll start with you, Kelly. Thank you again for being here. Unmute yourself and identify yourself and proceed.
Thank you, and good morning. You can hear.
You are a little
Yes.
kind of going in and out. I think you're good now.
Is this better?
Yes.
Okay.
Yes.
Thank you. Good morning, Chair and members of the House Judiciary Committee. My name is Kelly Carroll, and I am the mother of Emily Hammond, who was murdered in 2021. I am also an advocate for victims across Vermont who have been navigating the same system and same gaps for years. I want to take this opportunity to thank you for allowing us to testify on S-193, and I appreciate the recognition of the urgency. I appreciate the walkthrough that you did with, your committee did with House Corrections and Institutions yesterday. So thank you for that. I realize this is a very complex bill and it's coming over late in the session, and it's not leaving you much time to work with it or make any amendments or anything. So thank you very much. I want to begin with reminding you about one very important point. S-193 is not about a broad population. It is about a very small, specific group of individuals who are charged with serious violent offenses, often punishable by life sentences, who have been found not competent to stand trial. These are judicial findings made by the court, not simply medical determinations. I recognize that there are important considerations regarding individual rights, and those must be respected. At the same time, victims and communities also have rights, including the right to expect the state to provide appropriate monitoring, supervision, programming, and treatment when someone has demonstrated that they are a danger. While I understand Vermont's approach to compassionate sentences, public safety and the rights of victims and survivors must come first. Mental health challenges or disabilities warrant appropriate care, but they should not remove accountability when individuals have caused serious harm. The question that Vermont must answer is simple. What happens when someone no longer meets a clinical threshold but remains dangerous? Where do you place them? Back in the community, unsupervised to repeat the behavior? Our current system encourages escalation. We had an incident that happened the night before my daughter was murdered. Vermont State Police were called, our local agency was called, and he was left out in the community unsupervised with his mother, who emboldened him. And the next morning, my daughter was dead. So the system is not working. So where else do you place them? Do you put them in an unsecured group home with staff that are not trained to manage that level of risk? Again, our current system engages or encourages escalation. Elijah Campagna was found not competent for assault, deemed dangerous, and placed in an unsecured community group home where he lured a young woman there and was able to stab her to death with an untrained caregiver in the home. And that was in 2025. So we've already seen the outcomes of these choices, and they're not working. This is not a new bill. This is not a new problem. This is also a strong sense of deja vu. A similar forensic facility passed in 2023, only to have the facility component removed at the last minute in 2024 by House Human Services Committee. And I respectfully urge you to be mindful of that history as you consider S-193. Last week, House Corrections and Institutions had a preliminary walkthrough with Eric on S-193, and during that, they brought up Elizabeth Teague. And in 1991, Elizabeth Teague murdered her boss and wounded two co-workers in Bennington. She was found not competent to stand trial and has remained in DMH custody for 35 years. So Competency, not competent, that's a judicial finding. You have to be found competent before you can go for a not guilty by reason of insanity defense. She has not made that point yet because for 35 years, she has been refusing treatment and medication. And her case addresses involuntary medication. That should be something that competency restoration should be able to address. So think about that. 35 years. Think about everything that's changed in Vermont in 35 years, and yet how nothing has changed in cases like these. In 2010, Kathleen Smith was murdered in the Burlington area. Her family immediately began lobbying for competency restoration. Her killer spent 9 years manipulating the system through not competent findings. He eventually passed away in a hospital, but 15 years later, we're still discussing the same issue. Nothing has changed. And I just want to put that in context because a couple of weeks after Kathleen was murdered, Senator Phil Baruth was elected for the first time. So for 15 years, nothing has changed. And these are not isolated incidents, they're patterns. And just like the cases that I know about, that I found about only in the last few years, you heard testimony from Katie yesterday, 5 to 6 cases a year. That is our reality. And right now, many of these individuals are held in the Department of Corrections custody, not because they're in crisis, but because there is nowhere else to go. They are not in appropriate treatment settings. They are not being restored. And in some cases like mine, they're just refusing treatment altogether and the system allows it. So the cases stall for years. If someone is not restorable, but still creates a substantial risk of bodily injury to another person, what's the point? S-193 attempts to address this. Assistant State's Attorney Jared Bianchi is testifying before you later today. In Senate Judiciary, he testified on S-193, and he presented a video of Darren Pronto, my daughter's killer, stating in his own words that he can kill anybody he wants and the state can't do anything. And unfortunately, he's right. He had attempted murder. He went into DMH. He was released into the community. He was inappropriately supervised by our local agency. There were several incidents with other community members and public safety risks that were documented. The night before he murdered Emily, there was an incident, and it was all allowed to continue because mental health agencies are not comfortable reporting when people don't comply with conditions of release. It breaks the trust. So really think about having it under DOC and probation and parole, because at least if there's accountability, we might be able to avoid repeat offenses and creating new victims. So this is a gap, and I encourage you to ask Mr. Bianchi to see that video. Hopefully he brings it with him later today, because it's in Darren Pronto's own words, and that is a gap. This is definitely community safety failure. We need to be honest about what happens upon release. Community release without probation and parole is not working for this population. And there's other cases that would be appropriate for the forensic facility. And you've all heard about them. They've all been publicized since 22, 23. Jordan Lawyer, Brian Crossman, Matthew Gomes, Zayan Mavish Jamesh. I mentioned Elijah Campagna, James Perry. These are all people who have committed serious offenses. And just because there's mental health issues, that does not mean that accountability should be removed, and there should be treatment for them as well. Warehousing them in corrections is basically what we're doing, and that is not helping anybody. We have patterns of preventable violence in Vermont. They are not isolated incidents. Last week, House Corrections and Institutions was told that Vermont has approximately 167 psychiatric beds, with 156 that were filled as of late February. And I would ask you, how many of those are voluntary versus involuntary? Because facilities like the Berlin Psychiatric Hospital are not designed for this population. You have Karen coming up, Karen Barber Golnick afterwards. She can speak to that. And if you do put somebody in there, they are taking away a crisis bed for somebody probably not criminally intertwined that needs it. So I think you really need to take a look at that, because these hospitals face licensing constraints under CMS if they house individuals outside of their classifications, and they can risk losing their licensing. We do not have appropriate placement plans. And since the closure of the Waterbury State Hospital following Hurricane Irene, Vermont has been operating without a fully functional mental health infrastructure. The reliance on limited piecemeal bed capacity and voluntary outpatient treatment have created the gaps that we are now confronting, leaving the state without adequate tools to manage high-risk individuals appropriately. We really have not done right by the state since Irene has closed Waterbury. We failed many, many different populations within Vermont from that. And there are financial realities that need to be considered. Concerns are often raised about the cost of creating a forensic city, but what about a forensic system? But what about the cost to our communities when we do not? Incidents like those involving our local mental health provider, where Dale just fined them $483,000 for oversight failures, raise serious about whether we are placing individuals back into systems that are not equipped or adequately trained to manage them. Without proper structure, we risk repeating the same outcomes while shifting onto communities and agencies. And I recognize that there are important considerations regarding individual rights and those that must be respected. But as I said, victims and communities also have rights, and that includes the right that the state provides monitoring, supervision, programming, and treatment when someone demonstrates they are a danger. Conditions of release should not be viewed as an imposition. It should be expected. And compassion does not eliminate accountability. S-193 is not perfect, but this bill does address a small specific population, and the consequences of not addressing it are large. Because if someone is found not competent, if they are charged with a life sentence offense, if they are refusing treatment and they are still dangerous, then I think Vermonters have a right to know what the plan is from the state to keep the public safe, because right now there isn't one, and we cannot wait another 15 to 30 years to fix it. I would also urge the committee to carefully fact check claims that you hear when you hear testimonies. So when you are told that Vermont already has a forensic facility, please verify that with the Department of Mental Health, because we do not. When you are told Vermont has ample beds or adequate existing capacity for this best population, please verify that with DMH as well, because we do not. When legal aid comes in here and tells you that there is no gap or need, like they did to Senate Judiciary, I urge you to verify with DMH, because there is. DMH is best positioned to speak to the actual gaps and limitations of Vermont's current system. Given past experience on this topic, I would also strongly encourage you to evaluate and verify information presented, especially from some fellow legislators, so that decisions are grounded in accurate, consistent facts. Again, verify with DMH. S-193 is not a perfect bill, but it is a meaningful step forward. And given the delays in the Senate and the limited time remaining in the session, I respectfully urge that you continue to give this bill expedited attention so that it has fair opportunity to move forward. Public safety is not political. It's personal, and Vermonters have been waiting a long time for meaningful action on the issue. It's long overdue for real attention, and I hope this is the moment it begins. Thank you for your time and consideration.
Thank you very much, Kelly. And if you have the written testimony, if you could submit that to our committee assistant so we can post that as well. Questions for Kelly? At this point, it doesn't look like we have questions. I think I covered you. You gave us some good questions that we need to be asking over the next week or so as we get into this. The intent is to be taking a lot of testimony this week and next week. And I understand that the House or Committee on Corrections and Institutions will also be simultaneously taking testimony. So I think I'm not as concerned about the timing. We do have 6 weeks left, and this is a priority. So we'll be working on it. Angela, go ahead.
I just wanted to say did you want to answer?
No, I just wanted to ask a question, but I'll go after.
Well, I wanted to say thank you, and to say that I know that you've been advocating for this for a number of years now, and your knowledge is really helpful. That your perspective, not just as the perspective of a person who's had this tragic and horrible lived experience is important all by itself. But I guess I just want to say how I really value and honor and respect how you've established yourself as like an authority in this space, and your voice is really important. And so thank you for being here and for always being here.
Thank you. I appreciate that very, very much. My question was going to be, since Representative Lalonde mentioned not being concerned about time as much as I am, because I don't understand all the workings of it. But are there going to be opportunities for amendments? Because if there are, I would strongly encourage some conversation about that, especially with some input from Joanne Kortendick, who is Kathleen Smith's sister and has been advocating for 15 years regarding the wording on victims, and she's much better to speak about this. I know she has a concern about Section 1 now contemplates a hearing for individuals being returned to the facility. A subsection similar to Section G of Section 3 for not guilty by reason of insanity needs to be added to Section 1 of the bill. At any hearing under this section, the victim may express the victim's views concerning the offense and preferences for the person's placement in care, and the court may consider the victim's testimony. Without this added language, victims will have no voice in hearings related to those placed in the forensic facility who are placed there after being found not competent to stand trial. The other place in the bill where victims could be benefited by an amendment is Section 4C, under the definition of forensic facility relating to release of records. It contemplates release of records to the partners in the underlying criminal case. This would include state's attorneys, but it does not appear that they could be shared with the victims. It might be too big of an ask at this point, but from a victim's perspective, it is terribly frustrating to receive no information about status and circumstances surrounding accused once they are determined to be not competent to stand trial. And that could possibly pertain to NGIR. And I know I'm going over my time, Lee, and I apologize, but I do want to say last night I spoke with the brother of Cameron Phelan, who was murdered in 2020, and they're very, very frustrated at their case has been stalled. There's only, it's just not going anywhere. There has only been one competency evaluation that the family knows about. They don't know where she is. They don't know what the next steps are. And that's something that I'm trying to help them navigate the system with and connect them with Jennifer Poltman and all the great resources I've had. But if there is a possibility for amendments in victims, I will certainly see if I can get that submitted with my statement so that it is, but I do not want to delay the bill. That might be something that we have to take up with the next legislative session. We will be back.
So yeah, I mean,
And thank you.
yeah, we will be working on the bill and I anticipate just from our walkthrough, there are some couple areas where I thought there could be a little clarity, more clarity. So, we'll do our work and there probably will be amendments and we'll definitely hear from Jennifer Pullman and happy to have Joanne. If you could when you send the
Yeah,
information, if you could send me the contact information as well. So Ken, go
I
ahead.
will.
Hi, Kelly.
Thank you
Just,
very, very much.
Thank you.
Hi, Kelly. We're just way past time of dealing with this and giving you some peace. I appreciate what you've done, and I'm going to do everything I can, certainly to push this for you. And I appreciate everything you've done. So keep up the great work, and I guarantee you there'll be amendments. There always is, but we'll work on those too.
Thank you. And thank you again for listening. And thank you again to Leanne also for being here. I'll be quiet now.
Yeah, and just one final thing is if you have other areas that you think there's improvements, we're always open to hear, and I think there is time to consider improvements to this. So you're welcome to weigh in on that as well. So
yeah, you always have been, and I appreciate that very much.
Great. All right, thank you. So we'll go to Leanne next. Thank you, Leanne, for being here. Again, thank you, Kelly, for being here. We're going to unmute you. You need to unmute, and then we can proceed.
I think I'm on. Okay.
You're all set now. Thank you.
Okay. Thank you, Kelly. And thank you all for inviting me to speak. I have a couple different perspectives on this. October 2nd of 2022, my middle son was murdered in South Burlington. We are still waiting for sentencing. Thankfully, he was convicted. It was a double homicide. There was a murder in Burlington. 3 hours later, the same individual murdered my son. During this process, we've learned a lot. We've learned that victims don't have a whole lot of rights and that we were pretty much kept in the dark through the whole process. The individual had 3 different psych evaluations and was found competent. But I have to tell you that this has been probably the worst thing that could ever happen. Sorry. During this process, I lost my youngest son to a motorcycle accident in 2024. The process was drawn out in March of 2025. We were told we were going to have a trial. We drove to Vermont, made all the arrangements, gathered all our family, and the Friday before the trial was supposed to begin, they put in for yet another competency hearing psych evaluation. The trial happened in November, and he was found guilty on November 10th. And we are awaiting sentencing, which is supposed to happen at the end of this month. I think for me, it was even harder because I have worked in the mental health field in Vermont for a very long time. I worked as a case manager in a program called Second Spring, which is a step-down facility from the hospital and from prison, and we deal with high acuity population. I've worked at the Brattleboro Retreat on what they call their forensic floor, and most recently, I was the director of a MyPad program in Middlebury, Vermont, working for the counseling services of Addison County. I also, during that time, was a crisis clinician, so I am very well aware. I'm a QMHP, so I did a lot of involuntary and voluntary assessments. So I understand the system, and I understand that major pieces of it is broken. I have seen people that really should not have been on the streets, released to the streets without any supervision. I also really want you to know that I believe that if things are done with love and people are treated with respect and dignity in a humane environment, that the chances of a better outcome are tremendously increased. I I don't believe that um, we should be locking people away and just forgetting that they're there. And I honestly believe that if people are stabilized and can make better choices, that they do, that they honestly do. But a lot of people that are in the system have learned that our system is broken, and it's very easily manipulated because we're such a great state, because Vermont is so progressive and so caring and kind. And I don't believe anyone wants to change that. There is a way to manipulate things. So, having seen all the different programs in Vermont that there is available, I believe that this bill is vital, and that, like Kelly stated, there's a very small population that we're talking about. This is not a huge population, but it exists and we are ignoring it. And I also know that in the times we're in right now, it is really difficult to get money out of a budget for such a small population. But to think about that population is the population that goes out and murders people. What does it cost? What is the cost of a life? Like, I believe that if Kelly's daughter Emily's murder would have been somehow put in a facility where he could have got the treatment that he needed, this would have never occurred. I just think that we need to address this population. It is long overdue. And I am so thankful that you guys have carried this bill as far as it's gone. And I pray that it becomes what it needs to become. Thank you.
Thank you, Barbara.
Thank you so much, Leanne. I worked at CSAC too at one point. So the wealth of knowledge that you bring from working in so many programs, in addition to your family tragedy, which I'm very sorry about, and grateful to you as well for sharing that with us. I'm wondering, because on Mental Health Day, we had some people testifying here about this issue. And I wonder about the small number of people that try to manipulate the system, that refuse to be assessed or refuse treatment. If you have thoughts about policy change related to that, because I wondered if, one, it should be, if you refuse, we're going to assume you are not incompetent to stand trial at some point. And I just wondered what your thoughts were.
So I think that if they have the capability of refusing any kind of treatment or medication. So we had, when I was at Second Spring, I don't know if you're familiar with that program, but one of the things is they have to take their medication as prescribed in order to be there. And we had an extremely violent man who had been violent for years and years in the system. Nobody really wanted to touch him. He went through several different designated agencies. And while he was there, he really didn't want to be anywhere else. And so he started taking his medication. Within a couple of years, within almost instantly after starting his medication, within just like probably 30 days, he stopped assaulting people. And as far as I know to this day, he's out in his own apartment, in his own space. And he just didn't have the ability to recognize that the medication was what made him stable. That's not manipulating the system.
No.
That's just someone who was so ill that he didn't realize what was causing all of the chaos around him.
Sure.
anybody that does this for a living can tell when someone is refusing, when someone is manipulating the system, especially when you have a video of someone who says, I can just go kill someone and the state of Vermont won't do anything.
Right.
I believe that there are times when involuntary medication needs to be used, when people are extremely violent to themselves or to others. But I do believe that if someone is not willing to participate in the program, I'm not sure corrections is the place for this program to be. I believe they should have some oversight in it. Our Department of Mental Health does tend to get really touchy-feely sometimes with our pendulum needs to swing back into the middle. So I ran a program with people who are really hard to house and can be extremely violent, but our main rule was do everything with love. So I believe this can happen, but I also believe that we have to recognize that there is people who will manipulate the system. And they should just be, if you don't do ABC, then we are going to just assume that you're competent.
So thank you for that. One other question that I have is, Kelly mentioned that mental health agencies are reluctant to report somebody when they have violated conditions. And having worked at an organization that worked with people who had conditions of release, it was one of the sort of the main points being made at the beginning when somebody was admitted to the program, right? That everything is confidential except for this. And obviously we have to report a condition of release to corrections. So I'm wondering, it doesn't feel like it has to be as black and white as we mental health will lose the trust of people. And again, I don't know if your experience has been that mental health organizations have been reluctant, but they're like required to do that. So I'm curious.
So there's a thing called a ONH, and most forensic clients have that. It's an order of non-hospitalization. I will tell you that it's pretty much not worth the paper that it's written on. You put in for a revocation of the ONH, and if they have started to take their medication, it doesn't matter if they started to take it that morning. If they have not been violent in 24 hours, whatever the case may be, it doesn't get heard. It doesn't go any further. So it's really hard for a designated agency to get any traction. I would hope that it's reported. It definitely needs to be reported and documented. But again, it just happened once. And now he's back on track. A lot of that occurs. And it's really hard to build a file for the ONH revocation when not all of this is really being taken serious.
Well,
So we had a client who didn't kill anybody, but he shot 3 people, and time after time after time he would violate his ONH, and time after time after time he would get a restart. And so it happens. It's unfortunate, but it happens.
well, I think also what I took away from some of the testimony we got earlier was that if the local mental health agency, who is the one having contact or not having contact, if the person isn't showing, feels differently than the Department of Mental Health, there's no sort of place to go and get like another opinion on what should happen. Like it just, so just making sure that things really match up from the people who are the ones having that daily contact or failing to have that daily contact and expressing concerns. And again, wondering if, you know, if that goes back to the court or how to make sure the
So I do
voices are
have
heard on the local level.
So I do have a sort of remedy for that. If a designated agency had to write a monthly report on that person and send it to a point person, and include any kind of documentation about maybe a scary interaction with the client, or maybe no shows for that month, maybe the fact that they didn't pick up their medication or that they're not taking their medication. If that form had to be sent to someone at DMH, I think that the designated agency would look at things a little differently.
Interesting idea. No, that's great. And maybe it should go to the state attorney's offices. Like, I don't know where else it should go. But
Absolutely. I know that we used to deal with Ira. He was one of the attorney generals, I think. He dealt with all of the ONHs. And so he definitely wanted to know about stuff like that. But I think if there's reporting that has to be done every month in a timely manner, you will see a different response from designated agencies.
thank you.
All right, thank you, Leanne. Any other questions? Well, let's go to Kelly, wanted to weigh in on what we were just talking about, and then we can go back to any other questions to Leanne.
Yeah, I just, thank you. I just wanted to make a couple of comments when I had referenced trust with the agencies, Representative Rachelson, you may remember way back a few years ago, we had S3, which became Act 57, which was the ability for the state's attorney to request, not guarantee, but request a competency evaluation after the defense not competent was done, and also gave victims the rights to be notified when offenders are moved. But anyway, during that testimony in House Healthcare, it was constantly brought up that the agencies felt that they would lose trust. They did not want to be the monitoring. They didn't want to be recording every little thing because they felt that they would lose the trust. So that's where a lot of that came from. I think Anne's suggestion is a fantastic idea, although I'm not sure what Karen will say from the DMH perspective, but I do think with the small population or something like that, that is helpful. And I think part of the problem is that, you know, not necessarily, problem is that we're all voluntary for mental health. And if someone, and again, Karen or mental health, the DMH consider this, but it's my understanding that not everyone who has mental health issues realize that they have mental health issues. And the minute they want, you know, they say no, sometimes they're released. That's my personal experience with something that happened with Emily in suicide. But, you know, I just think that we have to take a look at not locking everybody up, but that there are certain times when the voluntary only has gotten us into the mess that we're in. And I just wanted to comment on cost. I know everybody's talking about cost. This is a couple of years down the road. We still have to deal with this population between now and 28, 29, if it goes forward. But, you know, I saw a headline last week, I think it was, we found $82 million for homelessness. The one lone no vote in the Senate is looking at creating a legal defense fund. Excuse me. So if we find money for things like that, I think we can find money for this. And I think that maybe we're already spending that money either in corrections now or through the agencies in that. And maybe we just need to look at reallocating some of our funds. So thank you.
Thank you. Any other questions for Leanne or for Kelly? I don't see it. Thank you very much again, Leanne and Kelly. I really appreciate the testimony. You're welcome to listen in, obviously, the rest of the testimony. So we'll go
Thank
to,
you.
Yeah, thank you. So
I just wanted to thank you for the opportunity to be heard.
No, absolutely. And like I will repeat what Angela said, your voice is very important, and we do appreciate your expertise on this as well. So we'll go to Jared next, and after Jared, we can take a break.
And Mr. Chair, I was still putting some final touches on the presentation.
Okay, well, we'll take our break. We'll take our break now. So we'll start up again at 10 o'clock.
My apologies.
No problem. No, that's fine. So we'll go off live.
Procrastinating to the last minute.
Sorry,
the window got bundled. We're still live.